Hello everyone, this is Payal Agarwal.
Hi, this is Pammy Jaiswal.
It's been a while since our last episode on contra trade restrictions. You can view the same on our channel. The link is available in the description box below. In our today's episode, we will be discussing with the concept of trading window closure. What exactly is trading window closure? To whom does it apply to? And when we say whom does it apply to, is there a concept of selectively applying it to some, or is it applicable to all at the same time? What are the mandatory trading window closure requirements? And are there any exceptions there too? Is there any intimation also required to be given to the stock exchanges? And a relatively new concept of freezing of PAN for designated persons during trading window closure. So let us begin by understanding what trading window closure is. Trading window technically is just a notional window, and its closure implies that the trading cannot be done by certain persons for whom the trading window has been closed. The trading window closure applies to designated persons and their immediate relatives. Now, when is the trading window closed? The trading window is closed whenever the compliance officer feels that there is some UPSI in the company which the DPs may have access to with regard to their role and position. Apart from the discretion of compliance officer, trading window is also required to be closed specifically for one event which is given there in the code of conduct, which is the quarterly financial results. So as for the quarterly financial results, the trading window is closed at the end of the quarter till the board meeting in which the financial results are approved and for 48 hours thereafter.
Right. So, Payal, as you rightly mentioned, that this trading window, this notional window through which trading is regulated and restricted, it is done for the designated persons, right? Now, this is a very question, it's a very interesting question to discuss that whenever the trading window is closed, is it closed for all the designated persons in a listed entity, or is there a possibility that the trading window can be selectively closed for a selected group of DPs? Now, as you rightly mentioned, that whenever the designated persons have access to UPSI in a listed entity, the compliance officer closes the trading window for them. So, in our view, it is quite a possible situation, and in fact, it is also observed that in various cases in a listed entity, the trading window which is closed for specific events during a financial year and not the routine trading window closure. It is done for even a selected group of DPs. For example, if the company, if the listed entity has 20 DPs identified, out of the 20 DPs, there can be a situation that a proposed restructuring proposal is being discussed at a very senior level, which is only, privy to, let's say, only 8 designated persons in the listed entity. So the compliance officer will close the trading window because of this UPSI for only those 8 designated persons and not the 20 designated persons. Now, coming to the next part of the discussion, whenever the trading window is closed, is it mandatory that the compliance officer informs the stock exchange about such closure? Now, let's understand, the trading window is closed for the designated persons, not for the stock exchanges. So it is important for the compliance officer to inform the designated persons that, hey, look, you cannot trade during this trading window closure period. Now, as a matter of practice, we've seen that companies do inform the closure of trading window, but that again is for the routine trading window closure that happens for the quarterly financial results. In fact, there was a circular under the erstwhile insider trading regulations 1992 where there was a requirement of informing the stock exchange about the closure of trading window. But until December 2023, in fact, companies here also would only, as a practice, inform the routine trading window closure. Post December 2023 stock exchange circular, there is a specific format in which the intimation for trading window closure has to be given. That again for the routine trading window closures in our view, and not for the specific trading window closures that take place during a financial year. Coming to the third part of the discussion, whenever trading window happens, is there a possibility that the designated persons can still trade during the trading window closure period? Because it's a closure, right? But as per the insider trading regulations, there are few exceptions that allows the designated persons to trade even during the trading window closure period. Now, what are those? To mention some of them, for example, if there are transactions done in accordance with the SEBI regulations, for example, there is a further rights offer, or there is a further public offer, or there's a preferential issue that has happened, or let's say there is an exercise of ESOPs. In that case, also the trading window closure does not apply. In fact, there are situations where the trade happens between the designated persons and insiders who are privy to the same UPSI through a block dealer or off market transfer. In that case, also the exclusion of trading window comes into picture. So yes, so as we mentioned, exclusions mean that it is already assumed that there is the UPSI, the existence of UPSI will have no will actually give no benefit to the insider or the designated persons, even when they go ahead with this particular transaction as a part of the exclusions.
Right. With this, we move to the last segment of today's episode, which is freezing of PAN for designated persons. So, why the need for freezing of PAN? Trading window closure, as we know, is just a word of caution. It is an intimation given to the designated persons to not trade since they are in possession of UPSI belonging to the company. Now, since there may still be a case that designated persons ignoring or maybe unwillingly make such trade, which is not an exception to the trading window closure requirements during a trading window closure period. For this, a framework has been introduced for freezing of PAN of such designated persons at the depositories level itself, so that trading cannot happen of such from such PAN during the trading window closure period. This freezing of PAN was first made applicable with effect from the quarter ending 30 September 2022, and since financial year 23-24 it has been made applicable on all listed companies. However, this freezing of PAN is applicable only with respect to the quarterly trading window closure for financial results. It is currently not applicable for the other transactions for which trading window may have to be closed. Similarly, the closure is only applicable for the designated persons. It does not extend its applicability to the immediate relatives of the designated persons as of current date. It might be in future that it may be a pilot program which may be extended in future. In any event, whether the trading window be closed or not, whether the PAN be freezed or not, wherever a designated person has access to some UPSI, or for that matter, any insider has access to a UPSI, he or she is not allowed to trade while in possession of UPSI.
Right.
That remains the principle of insider trading regulations. With this, we conclude our episode today. We will meet again for our next episode on structured digital database,
which will actually be our last episode on the PIT regulation series.
Yes.
Thank you.
Thank you.